Welcome to our Foreign Excellent webinar series, which is sponsored by Black Hills IP and SLW Institute. Black Hills IP is a US-based service provider offering IP docketing, paralegal, analytics, and annuity services. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together experts to talk about strategies and best practices for patenting in key foreign countries. Today, we have a couple of our friends from FB Rice joining us to talk about the Malaysia patent system, actually intellectual property system, as they're going to talk about patents, trademarks, and designs. My name is Greg Stark. I am a principal with the Schwegman, Lundberg, and Wissner law firm. I have over 10 years of experience in counseling clients in strategic patent development, clearance work, and navigating post-grant proceedings. With me today are Rachel Hook and Ingrid Jafari from the FB Rice firm in Australia, and I'll let them each introduce themselves briefly.
Thanks, Greg. My name's Rachel Hook. I'm a partner at FB Rice and head the medical device, medical technology team. You might be wondering why we're talking to you. We're based in Sydney, but FB Rice practices in Australia and New Zealand, and we also offer hub services into the ASEAN region. And my particular country of interest and responsibility is Malaysia.
Hi everyone, my name is Ingrid Jafari and I'm a patent attorney in our Informations Communications Technology team. I work primarily with software and computer implemented inventions.
Great, thank you Rachel and Ingrid, and welcome, and we appreciate you joining us. It's somewhat early in Australia right now, so we appreciate their helping us out.
Pleasure.
All right, the first few slides we're going to go through will provide some context for the Malaysian economy and patent system, just sort of briefly kind of giving us all a feel for how big this jurisdiction is and the size of the patent system in particular. The Malaysian patent system is relatively young. It started sometime in the mid-'80s, so it is certainly not the long-term developed patent system that you see in the United States or Western Europe. But so the Malaysian economy, you see there is populations around 31 million. The economy is looks like 38th in the world, and the GDP per capita is almost 29,000. You can see the GDP by sector. The main three sectors are agriculture, industry, and the service industry. Jumping right into the patent system, here we're looking at the top 10 Malaysian technologies. The interesting thing, I think, takeaway here is the top 5 categories are primarily around computers and information technologies, with civil engineering being somewhat of an outlier there, and that is probably largely driven by one of the large assignees in the patent system in Malaysia is the Malaysian government, which is shown on this next slide. So this is top patent assignees in Malaysia. The top assignee is actually the Ministry of the Government. I won't even attempt to pronounce their name, but you can see it written out there. I think the interesting other takeaway here out of the top assignees is that they're largely large multinational corporations from either Western Europe or the US, largely bunched around software, networking technologies, as well as healthcare, with somebody like Nissan Motor being somewhat of an outlier there in the technology area. Moving on to patent filings. Here it looks like our labels along the side maybe has gotten cut off, unfortunately, but the line on the bottom there is actually showing us Malaysia. And this is non-resident filings. Here, Malaysia has somewhere around 6,100 filings in the last year that was being shown. But I won't linger here because the slide is not there. There we have some patents in force in Malaysia. Is 25,000 patents. Again, the patent system is relatively young, so that's something to keep in mind. But it is a much smaller jurisdiction than a lot of the other ones we have discussed in past Foreign Excellence series, and maybe jurisdictions that a lot of us are more familiar with. However, I think Malaysia has, as Rachel and Ingrid will demonstrate in their part of the discussion today, I think there's some interesting opportunities there for gaining protection. The last sort of introductory slide that we're going to talk about today really, I think, is one that is sort of critical importance when looking at strategic portfolio development, and that's really what is it going to cost to, first of all, get your patent. So here we're showing that as a patent acquisition cost, the lower bar. And then one that I think is often overlooked is the annuities and how much is it going to cost to keep that patent in force over its lifetime. And here we can see that Malaysia, the costs are relatively low, particularly in comparison to places like Japan and China. And so, it may be a smaller jurisdiction, but at least it's a jurisdiction where, maybe obtaining some critical coverage won't break the bank. So something to keep in mind. At this point, I will hand over the presentation to Rachel to really get into the meat of why we'd like to think about protecting our intellectual property in Malaysia and how to go about doing so.
Thanks, Greg. Yes, why file in Malaysia? It is a very diverse country and it is still developing, but it does have clear aspirations to become a high-income nation. When we look at the 11th Economic Plan, which sets the economic goals from 2016 to 2020, the government have identified key areas to achieve this. One of them, when we look at it, is the translation of innovation into wealth. So, of course, the handling of IP does play an important part for anyone considering Malaysia. So we see that it's strategically located in Southeast Asia. It is right next door to Singapore, a big powerhouse of Singapore. And that point of having a well-developed infrastructure and productive workforce is quite true. And I believe it stems from the 80s and 90s where manufacturing really bloomed, and as well as having large natural resources such as tin, rubber, and oil. So they have developed this infrastructure, and they do have a strong and good workforce. I think, I'm not sure who's on the line, but I work in medical devices, and I know in Minneapolis, for example, there's a real hub of medical devices, and this is a key area of industry in Malaysia. It's really got a thriving medical device industry, which stems from the kind of rubber latex origins, and it's now supported by quite a lot of secondary industries. So the two-way trade for Malaysia's medical device industry I think the figures are from 2014, was 1.98 billion. So and 19% of that was imported from the US and around 43% from Malaysia to the US. So this particular sector was identified specifically in that 11th Economic Plan. And we see examples of big multinational companies there, such as Agilent, B. Braun, St. Jude, CR Bard, ResMed, to name just but a few. So Malaysia is striving towards this high income status, but it has a very large middle income bracket at this point in time. And, part of this striving for the status will obviously involve working on this ease of doing business ranking. While not quite near the dizzying heights of Singapore, it does continue to make inroads. And I think probably the aspect that taints it most would be corruption. It scored 52 out of 100 in the figures that I found available for 2015. Saying that, it is in the top 15 performers in dealing with construction permits, for example. Getting connected to the grid, there's an average of 31 days compared to 78 in OECD high-performing bracket countries. So, it is strategically located. It does have a good infrastructure and workforce, and it is working hard to address many of the issues such as corruption.
Malaysia is located in the Northern Hemisphere, just north of the equator. As you can see, neighbouring countries of Malaysia include Thailand, Indonesia and Brunei. And as Rachel pointed out, Malaysia is also very close to Singapore, and in fact you can drive to Singapore from Malaysia via a motorway bridge. Geographically, Malaysia is the 66th largest country in the world. And as Greg mentioned earlier, the population of Malaysia is around 31 million. To put this into perspective, that's 1.3 times the population of Australia. Malaysia is split into two main islands, East and West. You may be familiar with the East Island of Malaysia for the World Heritage listed Mount Kinabalu located in Sabah. And on the west, we have the capital city, Kuala Lumpur. Malaysia has a mixed culture, and this is reflective of the country's rich history. The major influences today come from India, China, and the Middle East. The main religion is Islam. Although Malaysia is not officially a Muslim country, it is considered as an established religion of Malaysia, with 61% of the population identifying as Muslim. The other main religions include Buddhism, Christianity, and Hinduism. Malaysia includes multiple ethnic groups, predominantly Malay, which comprises around 50% of the population. The second largest ethnic group is the Chinese, which make up just under a quarter of the population, but in fact account for 70% of market capitalization. The Chinese in Malaysia form part of the larger so-called bamboo network, which is a term used to conceptualize the businesses operated by the overseas Chinese in the ASEAN region. Naturally, due to the history and presence of the Chinese, there is a large Chinese influence in Malaysia culturally. For example, Chinese New Year is celebrated as a public holiday. And finally, the official language of Malaysia is Bahasa Malaysia, or Bahasa Melayu, as it is known locally. However, there are also nearly 140 other languages also spoken in Malaysia.
Thanks, Ingrid. So if Malaysia is a key market or a market for you, the next step, and really the subject of this talk, is to ensure that you navigate the IP system in the best way possible for you. So we'll focus more on patents, but we will touch on trademarks and designs at the end. As with any jurisdiction, any market you're entering, an IP strategy is extremely important. You'll wish to consider the position and the acquisition of IP, including patents, and it's important to think through the processes involved, the costs, and any bars to you obtaining a patent for your invention in each jurisdiction. So that's that first cog of the wheel, that acquisition cog. We're going to talk about the processes, touch on costs. Greg mentioned the costs in his slide, which is interesting. But equally, if we look at this next cog in the wheel, consideration of what you're going to do with those acquired patent rights is of importance. So you should be thinking, is the system supportive of the assertion of my rights? How efficient is it? Are foreigners on the back foot in this jurisdiction? And what are the costs? And finally, although we won't dwell on this part, but it is extremely important, the matter of due diligence, undertaking an analysis of whether you have freedom to operate in that market. So will you infringe others' rights? So by the time you gear up, you enter the market, you really don't want a nasty surprise at that point where you're blocked from selling your product. So now Ingrid's going to give a bit of a background information on the governing laws in patents and the initial considerations of that first wheel, that acquisition cog.
Malaysia didn't officially have its own Patents Act until pretty recently. The Patents Act was enacted in 1983, with the accompanying regulations coming into force in 1986. Prior to the Patents Act, registration of a Malaysian patent was only possible via the re-registration of a granted United Kingdom patent. This is similar to the current registration procedure for a Hong Kong patent via Europe or the UK. Of course, since the Malaysian Patent Act has come in, this re-registration option isn't available anymore. Malaysia is a member of the Paris Convention, the World Intellectual Property Organization, and the Patent Cooperation Treaty. Again, Malaysia joined the PCT fairly recently in 2006. However, Malaysia is not yet a member of the Budapest Treaty, but accession is likely to occur in the near future. There are actually no provisions in the law for the deposits of biological materials. So the Malaysian Patent Office generally requires the applicant to execute a statutory declaration confirming that they will provide a sample if and when requested to. There are two types of patent protection in Malaysia: the standard invention patent, which is similar to standard applications in Australia, or the utility patent of the United States. The Malaysian patent system also provides for a utility innovation patent, which protects any innovation that creates a new product or process, or any new improvement of a known product or process that is capable of industrial application. The main difference between the standard and innovation patent is a lower threshold of patentability. So this is similar to Germany, China, and Australia, in that Malaysia has a two-tier patent protection system.
So back to that cog in the wheel and the acquisition considerations. There's no point in entering a jurisdiction if you can't get a patent for your subject matter. So this schematic, just trying to show a comparison between Australia and Malaysia, and apologies, it's a bit Australia-centric. I was going to replace Australia with that circle with the US, but the way that the US is handling 101 issues, probably Australia's still got a broader scope on the spectrum of what's patentable. Look, in Malaysia, that's maybe a bit extreme, that graph, because it's actually quite a lot is patentable. You'll see down the side there, if you've got anything like in most countries, if it's mechanical, a medical device, it's chemistry, that's all fine. But not surprisingly, any discoveries or scientific theories, animal varieties, plant varieties, biological processes for their production, that is the animal production. If it's a scheme or a business method, then those are not patentable. In my field, obviously, the methods for treatment of humans or animals by surgery or therapy, and that's diagnostic methods as well. That is not patentable in Malaysia, but that's not unusual. We can get patents for that in Australia, and you can in the US, but we would be the outliers there. There is a further restriction in Malaysia, and that's if the patentable subject matter is contrary to morality, but I haven't come across that in my practice yet.
Looking at computer implemented inventions, officially software as such, mathematical methods and business methods are not patentable. In particular, for computer implemented inventions, it is not uncommon to receive objections to the subject matter in the first office action. Navigating this kind of objection can be difficult, as there are no official guidelines about approaching the topic. This is unlike, say, the US, where the examiner guidelines on 101 objections are readily available to you. From our experience in prosecuting computer implemented inventions, including those of a business feel, The European approach tends to have good traction with the examiners. So this includes demonstrating that the claimed invention represents a technical solution to a technical problem. Now for a brief overview of the patent system for both standard and innovation patent applications. The term of a standard patent is 20 years, and interestingly, for an innovation patent, it is also possible to achieve 20 years of protection. The initial term of an innovation patent is 10 years, and this is extendable to 20 years. For both standard and innovation patents, absolute novelty and industrial applicability is required. However, a standard patent application has the higher threshold of inventive step, as innovation patents do not require an inventive step. Innovation patents are also limited to one claim only. Publication of a standard patent application occurs at 18 months from the priority date. For an innovation patent, publication occurs around grant, which can occur relatively quickly due to the lower standards of patentability. Therefore, if an applicant desires earlier publication for commercial reasons, pursuing an innovation patent may be a worthwhile strategy. You can also convert from a standard application to an innovation patent. For example, if you are facing difficulties proving inventive step in prosecution. You can also convert from an innovation patent to a standard patent application during the innovation patent pendency. However, you cannot have both types of patents for the same invention. For both standard and innovation patents, a novelty grace period of 12 months applies prior to the date of filing the complete Malaysian application. However, this only applies for direct or indirect disclosure. So this means that commercial use is not included in this grace period. Malaysia does have a provisional application filing system, much like the US and Australia. So it is possible to file an initial provisional application to secure a priority date and follow this up with a complete application in 12 months' time. Now taking a brief look at the filing requirements for both direct filings and national phase filings into Malaysia. The official languages of the Malaysian Patent Office are English and Bahasa Malaysia. However, in practice, nearly all applications are filed in English. Now, this makes sense as most applicants are non-residents. It also makes sense as applicants who file in Malaysia will likely be filing elsewhere in the world as part of their overall patent strategy. Although the official language is both English and Bahasa Malaysia, actually, the English translation of the specification is mandatory at filing. So the good news is there is no need to translate the specification into Bahasa Malaysia for filing. Other documents required at filing include the appointment of agent form and a statement from the applicant regarding their derivation of rights from the inventors. However, these can be submitted after filing. The official fees must also be paid at filing, including excess claim fees, which are around $5 per claim for each claim over 10. It's good to know that a certified copy of the priority document is not required at filing. However, the examiner has the discretion to request a copy during examination. So overall, what you should know about this is that urgent filings are entirely possible in Malaysia, as really only the English specification and the fees are absolutely required at the time of filing. And in practice, this will be readily available to you. Malaysia is a 30-month national phase entry country. This deadline is extendable, but you will need to provide reasons and sound evidence, as well as pay late fees.
Okay, so once you've met all the filing requirements, you've filed the application, it moves into the examination phase. And at this point, there's an automatic preliminary examination. That's really a formalities examination to look at any non-compliance, an opportunity to file those further documents that Ingrid mentioned. If everything's not in order, you will receive a preliminary examination adverse report. And at that point, you've got 3 months to respond and fix things up. Maybe the authorization of agent needs to be filed, et cetera, et cetera. So you have an opportunity at that time. Once that has been achieved, you will get a preliminary examination clear report, and it will move along the line to the substantive examination part. So within 18 months from the filing date of a Malaysian application, or 4 years from the PCT filing date, you must request either some form of substantive examination. I say some form because there's 2 types. There's normal or modified substantive examination. You can't really extend this deadline. You can request deferment, but if you fail to act on it, on the requesting examination, you could lapse your application. So you should be aware of that. If you're not ready to, you can request a deferment, and I'll mention that later. So, sorry, the slides are a bit slow there. There we go. So looking first of all at the normal substantive examination, that's a regular full examination of the application. The Malaysian examiner will conduct a search and examination and will examine it, but if an applicant's filed any patent applications for the same or substantially the same invention in any of these countries that I've listed here on the slide, then it is necessary to provide the filing details of those applications and any available search and examination results. So you've got to file that. The examiner won't wait for that to come. They will start examination, but you are required to provide that. It's a type of duty of disclosure. And you'll have to file certified English translations for all documents that are not in English. This particular duty of disclosure, it's not like the US where it extends right through to grant. It only is applied to the examination phase. But if you deliberately fail to file any documents, you could ultimately invalidate your patent. So it is important to take that seriously and in good faith file any search and examination results that you may have. And the results of those searches are usually pretty highly influential on the Malaysian examination. So modified substantive examination, the other option, it's a simplified examination process, and it does require an applicant to amend the specifications of everything that, the description, drawings, and claims in line with a foreign granted patent in one of these countries listed on the slide. And for that reason, it's necessary to, with that request, file a certified copy of the foreign patent, an English translation if it's not in English, and the necessary amendments that will be required to bring it into conformity with that foreign patent. With the modified examination, there's more limited grounds of examination, and in that regard, it's limited to novelty, patentable subject matter, and a review of whether it complies with that foreign patent that the applicant's relying on. Before I leave this slide, I do want to mention deferment of examination. I mentioned that earlier. So if the information and the documents that are required to support a request for both normal or modified are not available, you can actually request a deferment. There's no official fee for that. And from August 2006, I believe, that term is 5 years from the Malaysian filing date or the international filing date. So you can extend it out. You are probably sitting there waiting for those search and examination results at some point. And particularly if you filed a request for modified examination and you're actually waiting for the grant of a patent, that may not happen in a short period, but 5 years is hopefully enough time to secure that grant. But fear not, even if you run up into that 5-year term, and you've gone down the modified route and you still don't have the granted patent in the foreign jurisdiction, you can flip back into normal substantive examination, but you've got a 3-month window to do that at the end of that extension period. So we've looked at deferment, but the opposite, if you want to accelerate your examination, there are a number of ways to do so. This first one, I'll quickly go through. It's expedited examination. It's got quite a high fee, and it's limited to direct filings into Malaysia anyway. So really, most of our clients wouldn't use this option. Next option is the PPH. You may be familiar and have used various PPH applications around the world. There are many. In Malaysia, there are some pilot programs between the JPO and the EPO, and it is an effective way of basically jumping the queue in examination. And because it doesn't attract an official fee, it's often an attractive option for clients if they wish to speed up examination. But something to consider in the ASEAN region, and one of my favorites, and in fact I have used this with several of my clients, is this ASPEC route. And that's the ASEAN Patent Examination Cooperation Treaty. So basically all those countries have got together and agreed that they'll share search and examination results. But it's a bit more than that. It doesn't just speed up the examination. What we're seeing is if you do get grant in one jurisdiction, so the primary country, the other countries tend to rubber stamp that grant. So I would always choose, my preference for the search and examination in the primary country would be Singapore, for example. And just an add-on to that, what we do in Australia, we've got a very quick expedited examination process. So we can get allowance of claims in Australia within a matter of a month or two. We often will use that. We've got a PPH with Singapore. We'll PPH it into Singapore. We get allowance or grant of claims in Singapore in about usually 10 to 12 months. And then we use those claims to file with the ASPEC program into other countries. So there's no official fee with that as well. And all the filing documents are in English. So it's actually, if you're filing in multiple ASEAN countries, and even if you don't necessarily want to use it to speed things up, it does streamline the process. And so you end up with less office actions, and therefore across the board, we're seeing less cost. So it's something to think about as an option if that region is of interest to you. Other considerations that may interest you, amendments, just briefly, they can be filed during the pendency of that application. There are limitations on the amendments you can make after grant, but you can make them. And if there are court proceedings, you can't make any amendments to the claims, which I probably won't have time to go into, but that's been very problematic in the courts because the courts see that they don't have jurisdiction to amend patent claims, and they've ended in a bit of a mess there. The amendments clearly can't go beyond the disclosure of the application as filed. Other things to think about if you want to file a divisional application, the deadline to do so is 3 months from the first examination report. Or if you receive a lack of unity of invention objection further down the track, then you do have 3 months from that objection. But we would say if a divisional is required, err on the side of caution, file it within 3 months of that first examination report. And multiple divisionals are allowed, so that daisy chaining is permissible in Malaysia. And interestingly, there's no pre or post-grant opposition proceedings in Malaysia, unlike in Australia and Europe, for example. We, if any decision out of my IPO, which is the Patent Office in Malaysia, needs to be appealed, then it is appealed straight to the High Court. So no chance for opposition. Okay, moving on to that next cog in the wheel from that slide. We've acquired our patent rights. Now we unfortunately may need to enforce them. And in Malaysia, there's a number of things to consider there, a number of routes. The first thing we'll look at are public warning notices, and then look at other processes and remedies. So basically, the grant of a patent in Malaysia gives you an exclusive right to exploit the invention covered by the patent. So the right of exploitation covers making, importing, offering for sale, selling and using a product, if the patent covers a product, stocking that product for the purposes of offering for sale, selling or using. If the patent is granted for a process, then it's making, importing, offering for sale, selling and using a product obtained directly by means of that process. So first of all, looking at public warning notices, this is a kind of interesting, sorry, I'll just click again. Oh, Ingrid, can you get me back? Yeah. Sorry about that. Yeah, this is interesting, and it's something that you do see a bit more of in Southeast Asia, and in particular, it's quite widely used in Malaysia. So this is just an example of one where the SKB vision is basically putting the public on notice that there are infringing articles out there. And not only that, they're saying they've been successful in the High Court previously and getting a permanent injunction, and they're warning that any infringements will be punished. So I think it's seen as it could be used very positively, and the infringers look at this and say, heavens, we better stop, and they stop their actions. Or it is often just used as that kind of preliminary action before court proceedings. So looking at the court system, Malaysia introduced IP-specific courts in around 2007, which is quite a big step forward for that country. And actually before, I think, even China introduced them. And there's currently 15 sessions courts with criminal jurisdiction, and they deal primarily with counterfeiting and piracy cases. But there's 6 high courts with both civil and appellate jurisdictions, including an IP high court in the capital. So that's here. It's a single judge court. Again, we're a bit short of time, but I would put a note of caution because it is a single judge court. It is prone to that single judge's good decisions or bad decisions. And in fact, in that SKB case, when it went to the High Court, the patentee had to appeal to the Court of Appeals because the judge had compared the infringing product with the patentee's product rather than with the patentee's claim. In Australia, we've got a phrase that's a rookie error. I think it is. It's quite interesting for us to look at that, but the system is still developing. There is a will to introduce these courts, but perhaps be mindful that that single judge issue can bite you. Basically, in that court, if there's both infringement and validity issues, then the judge does have the discretion to hear both at the same time. When you go to court, you might be seeking an interlocutory injunction, and that is awarded at the discretion of the court. And considerations of, the usual issues will be considered by the court, and that's if there's a genuinely serious issue to be tried, and a review of where the justice of the case lies. That is the harm caused by granting the injunction, and the harm versus the harm caused by refusing it, and which party would suffer the greater injustice. The court would also have to consider, when issuing an interlocutory injunction, whether damages would constitute an adequate remedy, and that's something we're very familiar with here in Australia. Also, the court will see if there's been any delay in the application for this injunction. So if you do want to move fast and seek an interlocutory injunction, our recommendation would be to do so swiftly without undue delay. So in the courts, and especially with our single judge there is a reliance on expert witnesses, particularly in patent cases and highly technical patent cases. So you can present actually more than one witness. And just to point out, there's no doctrine of equivalence in Malaysia. Malaysia is a common law country, and it applies like Australia, a purposive construction. I was going to say like the UK as well, but they seem to be going down the track of doctrine of equivalence like the US. So we take a purposive construction rather than a purely literal one. And unlike the doctrine of equivalence, which applies a literal construction with the extension of protection to equivalence. So a slightly different view of infringement. So as I mentioned, Malaysia is a common law country. And whilst the courts will run the case based on Malaysian law, they will consider jurisprudence from other common law countries, and particularly the Commonwealth countries, such as the UK and Australia. If a plaintiff does prove infringement, the court will award damages. That takes place in a separate hearing to assess the damages suffered, and they're usually compensatory rather than punitive. The court also, beyond the interlocutory injunction, can grant a permanent injunction, and there are other remedies, such as the court being able to order the delivery up or the destruction of infringing goods. The award of costs is at the discretion of the court, but we do see most often costs are awarded. This is a pretty big range of costs. I think it's just to kind of show you that the kind of general quantum, not talking in the millions. As you're probably all aware, it does depend on the complexity of the case, whether you're running infringement and invalidity, the number of witnesses, the number of days in court. So just to give you a kind of flavor of what we see, minimum of 70,000, but it can be going into the hundreds of thousands USD. And it is possible to appeal the decision out of that high court. As of right, you can appeal to the Court of Appeals. Now, thereafter, a further appeal can be made to the federal court, but only if leave is granted by the federal court, and we would see that would typically only happen, much as in other jurisdictions in the US and the Supreme Court, where they wish to review a point of law. So that finishes our patent section. I'd like to just touch on trademarks briefly before Ingrid talks about designs. So the Trademarks Act 1976 and the regs of 97, that's the legislative framework for the protection of trademark rights and enforcement through civil redress. Malaysia is signatory to these classification treaties, the Nice Agreement and the Vienna Agreement. However, it's still not signatory yet to the Madrid Protocol. And I say yet, was supposed to be by 2015. And I just saw that it was supposed to have been acceded to the protocol by the end of 2017. Well, that's been and gone, or else the end of first quarter 2018. But to be fair, it could be happening quite soon, because my IPO, the Patent and Trademark Office, has already introduced electronic applications for the filing and maintenance of trademarks, as well as a publicly available electronic information system via the online database. So I think this is all signs that they're getting ready to accede to the Madrid Protocol. Briefly, this just provides you with a definition of mark, and you'll see their device, brand, heading, label, ticket, etc. Notably, non-traditional marks are not included there. Again, this may change when Malaysia accedes to the Madrid Protocol. The term is 10 years and renewable indefinitely for every 10 years. And there, just to mention that there is a non-use provision, so it's non-use for continuous period of 3 years or more, ending 1 month before the day on which the non-use application is filed. Okay, so on to trademark enforcement. I think, again, much effort has been made and the legislation improved to try and help trademark owners assert their rights against counterfeiters. There are still issues, but we'll just have a look at the routes that you can take. You can go down either a civil route or a criminal route, and we'll look first at the civil. That is via the High Court, one of the High Courts, and it does take an average of 12 to 18 months. We'd recommend this route where you can identify the key offending party, because you really need to establish its financial worth and make sure that they have assets that are sufficient to pay the damages and costs that are sought by you in that action. So there are several remedies that are offered in a civil suit, but including interlocutory or permanent injunctions, the delivery up or destruction of counterfeit goods, and damages are an account of profits. Even prior to that, you can get ex parte, injunctions such as an Anton Pillar in order, which you may or may not have heard of, but those can be used by a trademark rights holder to search and seize evidence from counterfeiters if it's suspected that they're going to destroy or dispose of those goods. Even before going down this civil route as well, you might want to consider, as we saw with the patents, those types of warning notices and cease and desist letters. Okay, so looking at the criminal route, it's actually governed by a separate act, the Trade Description Act 2011, which provides for criminal enforcement against infringement. And this act allows a trademark rights holder to apply for a trade description order. Once you've got a trade description order, you can take that to the ministry, and essentially what they do when they look at that, and where there's an infringing mark that's identical to a registered mark and there's clear evidence of infringement or passing off, then once that the order and the complaint is filed with the ministry, they have the power of arrest and search and seizure without a warrant. So you can basically use the police to go in there and do your work for you once you've got one of these orders. And following a raid, the ministry may prosecute the suspected counterfeiters, but they will have to seek advice from the Attorney General's chambers. I would just touch on there are some border measures in Malaysia, but they're so onerous and require the trademark owner to provide the date and time and arrival of suspect cargo, the ship name or number, the container number. So that's not often used, although the Trademark Act does empower customs to take action at the border if requested to by the rights holder.
Okay, just to wrap things up here, I'm going to briefly talk about industrial designs in Malaysia. Design protection is governed by the Designs Act 1996 and Regulations 1999. As with the Patents Act, this is fairly recent. Prior to this date, protection of designs in Malaysia was available by registering the design in the UK first and then subsequently re-registering it in Malaysia. Malaysia is not yet part of the Hague Agreement, but membership is anticipated. Taking a brief overview of design registrations, designs are considered to be features of shape, configuration, pattern, or ornamentation applied to an article by any industrial process, which in the finished article appeal to the eye and are judged by the eyes. A design must be in relation to an article of manufacture or handicraft, or be in relation to a part of an article of manufacture or handicraft. There are exclusions to design registrability, such as method or principle of construction, features that are dictated by function, as these would be more suitable for patent protection, integrated circuits, and designs that are contrary to public order and morality. The term of registration is 5 years, and this is renewable every 5 years thereafter for a maximum of 25 years. In Malaysia, no substantive examinations of designs are conducted. So this means that a design will be granted after a simple formalities examination. However, in practice, a brief novelty check against existing registered designs is performed. Now, in saying this, most designs do proceed to registration. It is possible that substantive objections, such as those relating to novelty, are raised during the formalities examination. However, the applicant will be given the opportunity to respond to such objections. So the main requirement really for registrability of a design is absolute novelty. So the design must differ by more than just immaterial details or features that are commonly used in the trade. When filing a design, a statement of novelty is required, which is generally a very simple statement, just pointing out where the novelty of the design lies. There is a 6-month grace period available for disclosure of a design, provided the disclosure was made in an officially recognized exhibition or disclosed unlawfully by a person other than the applicant. Similar to patents, there are no provisions for opposition to registration of a design. However, a person may apply directly to the IP High Court for revocation of a registered design on the grounds that the design was not new or that registration was procured by unlawful means. Registered designs are enforceable, and infringement proceedings can be commenced also by the IP High Court, provided the proceedings are commenced within 5 years of the infringing act. And you can expect design infringement proceedings will generally take around 2 years.
Well, that wraps up our review of the patent, trademark and design systems in Malaysia. If anybody has any questions, then please feel free to submit them and or else email us later.
And I would like to thank Ingrid and Rachel for this excellent informative review of the Malaysian intellectual property system. Again, as we do have a couple minutes here, if anybody has any questions, you can type that in the questions along the sidebar field. We'll hold here for a moment and see if anyone has any questions. Well, it doesn't look like anybody's coming through with questions at the moment, but again, as Rachel mentioned, if there are thoughts or questions that arise at a later time, feel free to contact any one of us speakers or Brian Ness at the SLW Institute, and we'll certainly endeavor to get you an answer. Again, wish to thank Rachel and Ingrid again for joining us in their early morning this morning. Hopefully they'll have a good day. If you enjoyed this presentation, we do have one more at least scheduled to talk about Singapore next month. And you're welcome to join us on Thursday, May 24th at 3 p.m. Central Daylight Time for a discussion of the Singapore intellectual property system. Well, if there's nothing further, I will sign off for today. And again, thank you for joining us.